Today we will address a fundamental topic for anyone practicing medicine: health law and medical liability. As medical students, you may be more familiar with diagnoses, treatments, or clinical protocols, but it is important to know that every medical act we perform has not only clinical consequences, but also legal implications. Medicine is not practiced in a vacuum. Every consultation, every procedure, every prescription occurs within a legal framework that regulates what must be done, how it must be done, and what can happen if it is not done adequately. This framework is called health law, and when that framework is transgressed, we enter the terrain of medical liability. Now, medical liability does not automatically mean guilt. It implies analyzing whether or not there was a breach of the norm, and if that breach caused harm. In other words, it allows us to understand what legal consequences a medical action may have. This first approach will be introductory and general. Later on, in Chapter 3 of the book, we will deepen our understanding of this topic with a more practical approach. In particular, we will study a section titled Management of Medical Legal Conflicts, where we will analyze how complaints are documented and faced, what role informed consent plays, how the LX artist is evaluated, and how expert opinions are integrated. Therefore, what we will see today is just the gateway to a more complete understanding of the legal framework in which medicine is practiced. And I want you to keep this key idea. The medical act is not only scientific and human, it is also legal. Have you ever stopped to think that a medical error, even without bad intention, can have legal consequences? That is precisely the reflection from which we start today. To understand medical liability, we must first understand what health law is. Health law is a branch of public law that regulates everything related to health, both in the public and private sectors. This includes not only doctors and hospitals, but also laboratories, healthcare systems, insurance companies, pharmaceutical companies, and any person or institution involved in the care, promotion, or regulation of health. But its objective is not simply to punish those who make mistakes. Health law exists to protect rights, guarantee quality services, and prevent harm. We can state that its main function is to ensure that every person has access to safe, ethical, and legal healthcare services. Where does this obligation stem from? It comes from Article 4 of our Constitution, which clearly establishes that every person has the right to the protection of health. This right is not just an aspiration, it is a mandate for the state. That is why the same article states that the law must define how that access is guaranteed and how institutions are organized to fulfill it. The law the Constitution refers to is the General Health Law. In its opening articles, Article 1, 1 bis, and 2, it defines the object of the law, the concept of health, and the objectives of the health system, such as medical care, sanitary regulation, surveillance, and the protection of well-being. This means that health law is not abstract. It is present every time we demand dignified treatment, whenever we request medical attention, or when the conditions under which a hospital must operate are regulated. And it is important to understand that this field is not static. Health law adapts to social, technological, and epidemiological changes. For example, it has evolved to include topics such as digital health, pandemic care, conscientious objection, and mental health with a human rights focus. In summary, health law defines the legal terrain upon which medicine operates, and knowing it is an essential tool to practice with responsibility, safety, and justice. Now that we understand what health law is, it is time to see how it relates to two fundamental elements of medical care: bioethics and patient safety. Let's start with bioethics. This is not a set of philosophical ideas disconnected from clinical practice. On the contrary, it is the framework of principles that guide our decisions as health professionals. The principles of bioethics are four: autonomy, beneficence, non-maleficence, and justice. And they all have a legal expression that gives them normative force. First, autonomy. Patient autonomy is not just an ethical recommendation. It is a legally recognized right. It is present in the General Health Law, Article 51, which establishes that every medical procedure must be performed with the informed consent of the patient, save for a few exceptions that we will explain later. 2. Beneficence and non-maleficence. These imply that our actions must always seek the patient's good and avoid any unnecessary harm. Although these exact terms do not appear literally in the law, they are reflected in the obligation to provide ethical, professional, responsible, and safe care. 3. Justice. Justice reminds us that medical care must be equitable. That is, everyone must have access to healthcare without discrimination. This principle is recognized right from the Constitution in Article 4 and developed in Articles 1, 1 bis, and 2 of the General Health Law. Now let's talk about patient safety. When we speak of this, we are talking about something more than just a good institutional wish. We refer to an active principle: preventing avoidable adverse events. This means avoiding errors like giving the wrong medication, confusing patients, omitting diagnoses, or performing procedures without the necessary conditions. Although the term patient safety is not expressly defined in the general health law, it is implicit in various regulatory provisions. For example, NOM 004, which regulates the clinical record, mandates documenting all care to guarantee traceability and continuity. And NOM 016 establishes the minimum conditions of hospital infrastructure for safe care. In other words, health law and bioethics are not parallel discourses. They complement each other. One gives legal form to ethical principles, and the other translates those principles into concrete actions that can be demanded and supervised. And here comes an inevitable question. What is more important when making a medical decision? Respecting the patient's autonomy, or protecting them from a risk they do not fully understand? Health law offers us tools to balance these tensions, without losing sight that the ultimate goal is medical care that is technically safe, ethically sound, and legally sustainable. When we talk about medical liability, it is necessary to distinguish its three main dimensions: civil, criminal, and administrative liability. These are not mutually exclusive. That is to say, a single medical act can generate legal consequences in all three avenues simultaneously. Let's start with civil liability. This arises when an action or omission by the professional causes harm to the patient, and that harm must be repaired. Generally, this reparation is economic. The goal is not to punish the doctor, but to compensate for the damage caused. The legal foundation lies in Articles 1910 and 1915 of the Federal Civil Code. These articles regulate illicit acts and liability arising from negligence, imprudence, or lack of skill, imperitia. A typical example would be failing to provide adequate follow-up to a patient, which ends up worsening their condition. Next, we move to criminal liability. Here, the medical act becomes a crime because it affects not only the patient but society as a whole. This is regulated by Articles 228 to 230 of the Federal Penal Code, which specifically address professional liability. In this case, sanctions can range from fines to prison or even the suspension of the professional license. Common examples include patient abandonment, injuries caused by gross negligence, or the unauthorized disclosure of medical secrets. It is worth noting that, unlike civil liability, criminal liability demands a higher degree of guilt. In many cases, it requires the participation of expert witnesses, peritos, to determine if the act went against the lex artis, the standard of care. Finally, there is administrative liability. This is perhaps the most common form in institutional contexts. It does not require evident harm to the patient, nor does it require a crime to be committed. It is enough to have violated a health standard, an institutional protocol, or a legal provision. It is regulated by the General Health Law and the General Law of Administrative Responsibilities. It is supervised by bodies such as COFEPRIS, state health secretariats, or internal hospital committees. Sanctions range from warnings or fines to disqualifications, suspensions, and even closures in the case of establishments. So, what is the underlying message? That medical liability exists not only when there is damage, but also whenever the legal, technical, or ethical framework that governs professional practice is broken. Therefore, a single act, for example, performing a surgery without informed consent, can lead to a civil lawsuit, a criminal complaint, and an administrative sanction, all at the same time. Knowing these avenues is not meant to generate fear. Rather, it is to help us understand the scope of our clinical decisions and to protect ourselves based on legal knowledge. Of all the legal elements that accompany the medical act, informed consent is one of the most important, both from an ethical and a legal point of view. It is often thought to be just a form signed before a surgery, but it is not. Informed consent is a process of communication between the doctor and the patient, a process in which the patient accepts or rejects a medical intervention based on the information provided, the risks, the benefits, the alternatives, and what might happen if nothing is done. But for that consent to be valid, it must meet 4 essential conditions. First, it must be voluntary. The patient must not feel pressured, manipulated, or forced to accept. Second, it must be given before the medical act, not afterwards. Third, it must be specific and revocable. It is not a blanket permission. It applies only to what was explained. And if the patient changes their mind, they can withdraw it at any time. And fourth, it must be adequately documented, especially in high-risk procedures. This implies that it must be signed in writing, recorded in the clinical record, and include the names of the professional who obtained it and the witnesses when indicated by the norm. The legal foundation for this obligation is found in Article 51 bis 2 of the General Health Law. This expressly establishes that no procedure may be performed without the informed consent of the patient, except for the exceptions provided by law. It is also regulated in the regulation of the General Health Law regarding the provision of medical care services, particularly in Articles 80 to 82, which explain the different types of consent: general, specific, and substitute. And finally, NOM 004 establishes that it must be registered in the clinical record, including the date, time, name of the procedure, and the signature of the patient or their legal representative. And what happens if it is not obtained or not documented? Even if the procedure was correct and the clinical outcome was good, the absence of consent can invalidate the physician's defense, and this can lead to civil, criminal, or administrative liability. Let's imagine a common scene. The patient signs the consent form in the waiting room without having received a clear explanation, without time to ask questions, and reading technical language they do not understand. Is that legally valid? No. Therefore, informed consent is not a protection for the doctor, it is a right of the patient. And at the same time, when applied correctly, it also legally protects the healthcare professional. That is why explaining, listening, recording, and respecting are actions just as important as diagnosing or prescribing, because there is no ethical medicine without autonomy, and there is no autonomy without information. When an adverse event occurs in medical care, one of the first questions that arises is, was it an unavoidable accident, or was there professional liability? To answer that question, law and forensic medicine use three fundamental concepts: negligence, lack of skill, imperizia, and imprudence. Let's go through them one by one. Let's start with negligence. Here we are talking about the omission of the duty of care. That is, when the doctor fails to do what they should have done, according to the accepted standards of their profession. For example, if a patient arrives with high fever, dyspnea, and a cardiac history, and the doctor does not order an electrocardiogram, they are being negligent. They are not acting in accordance with the lex artis. That is, the set of technical and ethical norms that define what is expected of a reasonably competent professional. For negligence to be established, three elements must be present. First, there must be an injury or harm to the patient. Second, the professional must have breached their duty. And third, there must be a direct cause and effect relationship between that omission and the harm. Now let's talk about lack of skill, imperizia. Here, the issue is not what was omitted, but rather what was performed without possessing the necessary preparation, skill, or experience. A classic example is a general practitioner attempting to perform a complex surgical procedure without formal training, or the professional who has not updated their knowledge in years and makes mistakes because they continue to rely on obsolete criteria. Lack of skill can stem from three causes: because it was never learned, because it was forgotten due to a lack of practice, or because, even if the theory is known, one lacks the ability to execute it correctly. And finally, we have imprudence. Here, the physician does possess the knowledge, but acts in a rash manner or without sufficient caution. For example, administering a medication without reviewing the medical history, or performing a procedure without adequate equipment, without the necessary support, or outside the appropriate hospital environment. Imprudence implies overconfidence, hasty action, or a disregard for safety protocols. Now, it is important to mention that these three concepts are not mutually exclusive. A single clinical case can combine elements of negligence, lack of skill, and imprudence all at the same time, and any one of them can give rise to civil, criminal, or administrative liability. As you can see, these categories are not just legal labels. They are tools that allow us to understand what went wrong, why it went wrong, and how to prevent it from happening again. And above all, they remind us that being a doctor is not just about having a degree or a license. It means staying updated, acting with caution, documenting rigorously, and respecting the limits of one's own professional competence. Let's look now at a case that, while seemingly simple, reveals many of the flaws that can generate medical liability. Let's imagine the following scenario. A patient arrives at the emergency department with a case of acute tonsillitis. The decision is made to initiate treatment with penicillin, which, clinically speaking, is an appropriate decision. But there is a crucial detail. The physician does not review the clinical record, nor do they ask about allergic history. Minutes after the administration of the antibiotic, the patient suffers severe anaphylactic shock. She requires emergency intubation and immediate admission to the intensive care unit. What happened here? Technically, the medication was indicated correctly, but a basic step of the clinical safety protocol was omitted, asking if the patient is allergic to penicillin. This omission represents a textbook case of medical negligence. The professional did not act in accordance with the expected duty of care. Furthermore, there was imprudence, because a potentially dangerous medication was administered without taking minimal precautions. And there is something even more serious. Neither the medical assessment nor the administration of the drug was adequately documented. This means that, if the case reaches a legal proceeding, the physician would have no way to prove they acted correctly. The consequences of this combination of errors can be severe. Civil liability for the physical and emotional damages to the patient. Criminal liability if it is determined there was gross negligence. And administrative sanctions for violating standards like NOM 004, which mandates documenting every relevant medical act in the clinical record. This example is useful for a very clear reason. This entire situation could have been avoided with a single question. A 3-second question that is part of any basic clinical interview. Are you allergic to any medication? And if it had been asked, if it had been documented, and if the protocol had been followed, this case likely never would have escalated. This example leaves us with a key lesson. In medicine, often the most costly errors are not technical, but errors of judgment, procedure, or omission. And those errors, when neither recorded nor prevented, are the ones that most easily generate legal consequences. The clinical record is often seen as an administrative burden, but in reality, it is one of the most important tools we have to guarantee patient safety and legally protect ourselves as health professionals. Think about this. If a medical act is not documented, from a legal standpoint, it is presumed not to have occurred. No matter how well a procedure was performed, if there is no written record, that care does not exist legally. The clinical record fulfills three essential functions. First, it reinforces patient safety because it allows for follow-up, traceability, and continuity of care. Second, it serves as objective proof in audits, expert assessments, claims, or legal processes. Third, it protects the professional, provided it is done well, clearly, chronologically, and completely. There are norms that regulate this document very precisely. The most important is NOM 004, which establishes the minimum elements the record must contain and how it must be structured, preserved, and safeguarded. Additionally, the General Health Law and its regulation on the provision of medical care services reinforce this obligation, indicating that medical personnel are directly responsible for its integrity. However, in daily practice, frequent errors occur that can have grave consequences. Incomplete or unsigned notes, implausible recording times, omission of orders or assessments, corrections that are not justified, use of ambiguous or unprofessional language. And here is the key point. Correct medical care without documentation is indefensible in a legal process, whereas imperfect care, but well documented, can be understood, evaluated, and even justified. Documenting well is not optional. It is part of the Medical Act. It is not just writing to cover yourself. It is writing to provide continuity, to back clinical decisions, and to build trust within the entire care team. Let's imagine a critical situation. A patient passes away, and weeks later, the family files a lawsuit for negligence. The physician's defense will depend largely on the record. If it is complete, clear, and signed, there are elements for defense. But if it is incomplete, contradictory, or absent, then not even the best lawyer nor the best expert witness will be able to reconstruct what was done right. Therefore, today more than ever, we must understand that the clinical record is also our tool for professional protection. So far, we have discussed norms, principles, obligations, and legal consequences. But the best way to approach all of this is not through fear, but through active and conscious prevention. Because practicing medicine safely does not depend solely on clinical knowledge. It also depends on how we anticipate legal risks which sometimes arise not from malice, but from carelessness, omission, or lack of preparation. Therefore, here I share with you 7 preventive strategies that can make the difference in your professional future. First, continuous training. Medicine changes. Regulations do too. A doctor who does not update themselves can end up acting with lack of skill, imperitia, even without knowing it. Staying up to date with new official standards, NOMs, with patient rights, or with institutional protocols is an act of responsibility. Second, rigorous clinical documentation. We said it already. What is not documented legally does not exist. Adopting good recording practices, even in high workload contexts, is a way to protect the patient and oneself. 3. Effective informed consent. This means that it is not enough to just have the signature. We must explain, ensure the patient understands, resolve doubts, and leave a written record of all of it. Fourth, clear and empathetic doctor-patient communication. Many lawsuits do not stem from clinical errors, but from misunderstandings, perceived mistreatment, or lack of explanations. Listening, informing, and treating with respect is one of the best legal tools, even if it doesn't appear in any legal code. 5. Strict application of the lex artis. Always acting in accordance with accepted medical standards. This includes following clinical guidelines, institutional protocols, and avoiding improvised decisions without documented justification. 6th, internal clinical audits. Periodically reviewing records, procedures, and quality of care is not bureaucracy. It is part of a culture of continuous improvement, where errors are detected before they turn into legal problems. 7. Specialized legal advice. You don't have to wait until you have a lawsuit to talk to a lawyer. Seeking legal guidance regarding doubts, family conflicts, or institutional situations is a practice that protects and helps you take better clinical decisions in difficult contexts. These strategies are not meant for extreme contexts. They are useful in day-to-day practice, in outpatient care, in the ER, in hospitalization, or in palliative care. And the key lies in accepting that being legally competent is also part of modern medical professionalism. We have reached the end of this introductory topic, and it is important to pause for a moment to reflect on everything we have discussed. Health law provides us with the regulatory framework. It tells us what is expected of health systems, institutions, and each of us as professionals. It helps us understand that medicine is not practiced in technical isolation, but within a network of norms, rights, and obligations. For its part, medical liability should not be viewed as a threat. It is not about assigning blame, but about understanding the consequences of our clinical decisions and acting with knowledge and prudence. Being conscious of this responsibility is a way to dignify the medical profession. Today we have seen a general overview. What health law is, how it relates to bioethics and patient safety, what the types of legal liability are, and what frequent errors can be avoided through prevention, documentation, and effective communication. But this topic does not end here. Later, in Chapter 3 of the book, we will revisit this axis from a more applied perspective, in a section titled Management of Medical Legal Conflicts. There, we will address how real legal processes are faced. What happens when there is a complaint? How an expert witness file, expediens peritial, is integrated. What the role of informed consent is in a trial, and how a health professional must prepare to testify or respond before an authority. Additionally, we will explore the ethical and technical instruments that allow us to prevent conflicts, clinical practice guidelines, bioethics committees, deontological codes, and quality management systems. The goal is not for you to become lawyers. It is for you to learn to recognize when a clinical act may have legal implications, and how to respond with responsibility and legal backing. Because practicing medicine today implies something more than knowing how to cure. It implies understanding how far our duties extend, what rights we protect, and how to respond if things do not go as expected. Legal training is, ultimately, a way to protect yourself, but it is also a way to honor the patient, the profession, and yourself.